Hi there, this is Erica Merrill, and I am the founder of Perfect Legal Video. I'm very excited to have with me on the attorney Jim Sorensen. He is a partner and owner of the Sorensen Van Leuven law firm, which is a law firm that represents credit unions in Florida and Georgia, and they are based out of Tallahassee. Welcome. Thank you so much for joining us today.
How are you doing today, Erica? Good to see you.
Great to see you. Well, today we're going to be talking about something very, very important. And as I understand it, when we were speaking before the interview, you are getting lots of questions about this topic. And so today we're going to be talking about repossession letters risk alert. And there's an alert that just came out by CUNA Mutual Group, and it has really dug up a lot of questions for your clients and people that follow you. So let's talk about that. What's happening with this recent CUNA alert?
Yes, we've gotten a lot of inquiries from our clients about this. CUNA Mutual put out a risk alert earlier this month, and they were alerting their customers, their insureds, to potential claims involving certain letters, and they just wanted them to be aware of it and be aware of some actions that could be taken. And as a result of that risk alert, we've been getting a lot of questions asked by clients, whether it be via email or telephone call.
So what is this risk alert regarding that it's just stirred up so many questions?
Yeah, the risk alert is regarding repossession letters. So these are letters that have to be sent once collateral is repossessed. Usually what we're talking about is repossession of automobiles, but it could be other types of collateral. And this risk alert is addressing those letters that must be sent when personal property is repossessed.
So it sounds to me like things could be missed if they are only thinking of personal property as automobile loans and that sort of thing. So could you give me an idea of what other personal property could they be referring to with this alert?
Yes, Erica, that's a good point. I think what people tend to think about, and a lot of my clients will reach out and say, what is this about the letters regarding automobile repossession? And they think purely about automobiles. And while automobile lending is kind of the biggest facet of lending most of my clients do, they do other loans that are secured by other personal property. And so it's important to understand this is beyond a motor vehicle. So when we talk about personal property, this would include an RV, a boat, mobile home, when a mobile home is considered personal property. In some states and in some situations, a mobile home can be either personal property or real property. But when a mobile home is personal property, these letters come into play. And so really personal property is anything that is collateral for a loan other than real estate or cash. So anything else, typically, again, we're talking about motor vehicles, RVs, campers, boats, mobile homes. Those are the typical ones. But sometimes we have clients who do other types of personal property lending.
Sounds like there might be some gotchas involved with trying to repossess some of those types of personal property. So if you could let us know, what are some of the dangers that your clients should be concerned about?
Yeah, so the dangers that this risk alert is trying to alert everybody to is it goes to the form letters that they should have. So every creditor, and in this case, we're talking about credit unions. So credit unions should have certain form letters. And so when you recover that collateral, whether it be the automobile or the boat or whatever it is, there's a notice that has to go out. We call it the notice of intent to sale letter. And then once the collateral is sold, there's a separate letter or separate notice that has to go out, typically called the explanation of deficiency. letter. So this risk alert is regarding those letters, and failure to use the proper form letter could lead to a lawsuit. And as the risk alert mentions, class action lawsuits. That's the concern, probably even further.
So, class action lawsuit, that sounds really scary for a credit union. It sounds like the type of thing that could really sink them. So, why would this be prone to a class action lawsuit?
Yeah, the class action lawsuits are a big concern, or a potential big concern. They can be very expensive to defend, and they can lead to substantial claims against a lender, credit union. These types of matters are prone to class action lawsuits because you're using a form. And so the thought process is, if you have a faulty form that you're using, and when I say faulty form, I'm talking about a form that doesn't comply with the law, doesn't meet the legal expectations or legal requirements. The assumption is you're sending that faulty form every time you repossess a car, or every time you repossess a boat, or every time you repossess any personal property collateral. And so a lawyer who's looking to sue somebody says, oh, I found ABC Credit Union. Their form is not up to par. Their form doesn't meet the legal requirements. And it appears they've been using this form for 3 years, or they suspect that. And so they start thinking, wow, there's 3 years worth of people who I can bring into this lawsuit, into this class action. And so these are very, these form claims, if you will, are very susceptible to class action lawsuits. And the reason is not only the form, but the fact that the claim as to each individual is the same. So the claim is, you sent a faulty letter, and as a result, they have a claim for damages. So in order to pursue a class action, you have to have a number of defendants with the same claim, and all those defendants, their claim has to be the same, or their cause of action and their damages have to be the same. So this is kind of the perfect storm for a class action lawsuit.
I mean, this seems like something where there are so many moving parts to getting this process done correctly. Because as you mentioned, it could be the wrong letter, but it could also have gone to the wrong address. It didn't go to all the people it was supposed to go to. I mean, it seems like in order to do it right, you'd have to somehow check and double check and check again, not only what you're sending, but who you're sending it to and how many people. I mean, it sounds like a lot. If they get this wrong, what would the potential damages be?
Yeah, the potential damages under Florida and Georgia law, in different states it could be different, but in Florida and Georgia, the potential damages are 10% of the principal balance of the loan. So the original balance of the loan. So you think about an automobile loan. Automobiles cost a lot. I don't know what the average amount is, but it's not uncommon for someone to have a $40,000 auto loan. So right there on a $40,000 auto loan, it's 10% of that is $4,000. And then on top of that, they get to recover the amount of interest that they've paid on the loan. So depending on how long they've had the loan, that would govern how much interest. And then on top of that, they get a forgiveness of the remaining balance of the loan. So if the automobile has been repossessed and the wrong letter was sent, and they still owe $20,000 on the loan, that $20,000 gets forgiven. The credit union can't pursue it. And on top of that, they get their court costs and attorney's fees if they're successful. So, this in a class action lawsuit, this can start adding up real quick. If you figure, the average person is going to get $5,000, $6,000, $7,000, and you have 100 of them, and you add the attorney's fees on top of that, you start talking about real money.
It sounds terrible. I mean, it's great that they have you to help protect them, and help them figure out. I know you do a lot of training with your clients on process, so your clients are probably a lot less um, in danger of having class action lawsuits. But I mean, really, like, what can a credit union do to limit their risk at this point?
Yeah, so to limit risk, I think the first thing, the most important thing, is to make sure you're using the correct form. And so, what happens in with a lot of, just in general, whether you're talking about a credit union or any lender, they get a form, it gets approved, and it goes into their system to be used. And over time, that form may get doctored, that form may get changed, it may get reformatted, sometimes unintentionally, sometimes intentionally. And when the form gets reformatted, or the form gets updated, or it goes into a new system, maybe their software changes, so the form in one system gets converted to a form in another system, there's always chances of that form being altered. And so we'll see situations where we maybe reviewed a letter for a client 10 years ago and it was compliant. And now the letter they're using 10 years later has morphed, has changed. And some of the required language or required information is gone. So, again, we would recommend that our clients on a regular basis, and, I think with something like this, it's so important that you would want to have this letter reviewed every 2 to 3 years by a lawyer who knows what they're doing, to make sure we have the right form. It's not been altered. We are using the right form. The second step is, and you've already alluded to this, Erica, is you've got to make sure your staff knows how to use this form, that we are sending it to the right people, we're sending it to the right address, that we're documenting our file appropriately, that the form is being completed correctly. These are really important. And the way you do that, obviously, is you have to have someone go and audit some of your accounts. You have to go to look at some of the repossessions that have been finished and have someone go through and confirm that everything was done correctly. And then, finally, where mistakes are found, you want to coach your employees, you want to train your employees so those mistakes don't continue to get repeated over and over again. And so, those are really the three important steps that an institution needs to take to protect themselves. And those are the things we're trying to help our clients with.
But I'm going to ask you, like, what are some of the common mistakes? But like, number one, not having an attorney help you like yourselves go through this process, because you just mentioning how all of your employees basically could make these mistakes and over and over and over again if they're not looking at what they're doing. So it's one of the scariest things I think that I've heard for a business. So what are some of the mistakes that maybe we haven't spoken of yet?
Sure. So, failure to send the notice to the proper individual. If there are 3 people who are supposed to get the letter, and the letter's only sent to 2 of the 3, you've not complied with the law. There could be a claim. And I think what happens is people forget or don't always understand who these letters need to go to. And so, the first letter, what we call the notice of intent to sale letter, that is supposed to go to every borrower on the loan and anyone who has a claim to the collateral, anyone who has a claim to the vehicle. So if we're talking about a motor vehicle, it would be anybody on the loan. So if you have, husband and wife on a loan, there needs to be a letter to husband and a letter to wife. And then if there's some third party who has a claim to the vehicle, that third party would also get a letter. And so sometimes we see where the letter only goes to 1 instead of 2 people. So we also see the letter going to an invalid address. It goes to the address on file, but that is no longer a valid address for the borrower. And the credit union maybe is aware of a better address, but the letter's never sent to that better address. So now the consumer has a claim. Look, you didn't send it to the right address. And then finally, the letter's just not being completed, or the letter's being incorrect. I actually happened to be with a client last week where, because of this risk alert, they wanted me to audit several of their repossession files. And I did that. And, the first letter I see, it has mistakes in it. The first letter I happened to pick, it had mistakes in it. Now I saw several others and they were all done right, and that's good. But human error can cause problems.
Yeah, we humans can get ourselves into a lot of trouble. So what can you and your firm do to help these credit unions avoid these mistakes and therefore avoid class action lawsuits, which is really the worst case scenario?
So the first thing we would do and we would suggest doing is reviewing their forms, making sure that the forms they're using are in compliance. So they're starting off with the right forms. Then to me, really the second step is for us to help them audit, to make sure that their staff is using these forms correctly and identifying any problems, any breakdowns in their processes. Sometimes it can just be a lack of clear training. It could be there's a way to automate the information coming in the forms to eliminate that human error. But the audit will tell you of that, and so that's something we can do. And then finally, we can work to train the staff to address these deficiencies, to make sure that the staff that is in charge of getting these letters out and seeing these letters go out, we can provide the training and the understanding so that they understand what they're supposed to do. And those are things that we do quite often for our clients. And certainly, it's a little bit of preventative maintenance to avoid these big potential claims down the road.
Yeah, a little preventative maintenance goes a long way.
It does.
So is there anything else that maybe we missed in talking about this topic today that you'd like to share with the audience?
Yeah, I think the last point that I would stress, and this is again another one that I think is overlooked, and it's important, is clients need to be careful when they're repossessing in another state. So I've got a credit union who's in Florida. Let's say their forms are up to date in Florida. They comply with the law. Their staff knows what they're doing, and they audit regularly, and they do a really good job. Rarely make a mistake. Any mistakes are quickly corrected. That's all great, but now all of a sudden they have a repossession in Virginia, just to pick a random state. And the question that comes up is, does the Florida form work in Virginia? And it may or it may not. There are 50 states, and these forms are based upon state law. So state law can vary. When we talk about Georgia, and I'm licensed in Georgia and Florida, I can tell you that there are some differences between Florida and Georgia. So the way you do some things in Georgia is different from Florida. And Virginia may be the same way. So when our clients have those situations arise and they need to recover a car in Virginia, my advice is we need to engage a lawyer who's licensed in Virginia, who knows the law and the legal requirements, to make sure that you are doing it right. And again, this goes to that preventative maintenance. It's going to cost a little bit of money, but in my opinion, that is money well spent to avoid the lawsuit down the road, to avoid having to pay your borrower back money. And so that preventative maintenance becomes important. And so there are times where a client says, okay, Jim, we need to repossess a car in Virginia. Do you know a lawyer in Virginia that we can reach out to make sure we're doing it correctly, that there aren't no gotchas that we're unaware of? And so we help put our clients in contact with those attorneys for those kind of one-off situations where they have to repossess a car in a state they don't regularly practice in, they don't regularly repossess in.
I think that's great. And certainly it's very valuable to have someone that can give you resources that you can trust, especially in such delicate situations as repossessing property. So I want to thank you so much for coming on again today. I mean, the information that you give us is always cutting edge, and we really appreciate it. There are so many interesting things happening right now with laws and regulations in this time in our lives. And it's very helpful to have someone like you help keep us up to date on those things.
Well, Erica, I want to thank you for having me on the program and allowing me to talk about these issues. These are important issues to my clients, and we want to make sure they get the information and they know what they need to be doing so we can assist them.
Well, thanks so much again. We'll look forward to talking to you in a couple of weeks. Have a great day.